Good afternoon, everybody. Welcome to the Center for Law and Global Affairs webinar series. The Center for Law and Global Affairs was established in 2008 to serve as the hub for all international legal research, academia, and student opportunities. In the last year, we've run conferences in Singapore, Switzerland, the Netherlands, and have represented the law school in Ukraine, Finland, and at the UN General Assembly meeting. Our students have held internships with the United Nations, courts in Timor-Leste, and in organizations in Malta, Geneva, Taiwan, and in many other places. This year's speakers have included the former U.S. Ambassador for Criminal Justice, the former Foreign Minister of Spain, and the chief negotiator to end apartheid in South Africa. The center is focused on looking at all legal issues that have a global impact, be they in trade law, human rights, or even in AI. Today, we are really honored to be able to present a renowned member of the ASU Law faculty, Professor Laura Coordes, to discuss the changes and developments in insolvency law in India. Professor Coordes' research focuses on bankruptcy and financial distress and includes commercial law, large corporate reorganizations, international and comparative insolvency law, and local government finance and policy. She teaches Chapter 11 bankruptcy, advanced bankruptcy, secure transactions, and contracts. She's an active member of the American Bankruptcy Institute, the ABI, and was honored as a member of the ABI's 40 Under 40 in 2020. Professor Coordes has served on the board of American Bankruptcy Law Journal from 2019 until 2022 and is an honorary master of the Arizona Bankruptcy American Inn of Court. She's currently serving as the reporter for the Uniform Law Commission's drafting committee on assignments for the benefit of creditors, and she is co-chair of the Insolvency Law Academy's Insolvency Scholars Forum. With Charles Tabb and Kara Bruce, Professor Coordes is the author of The Law of Bankruptcy, and with Eugenio Vaccari, Ysolt Maric, and Gio Quino, she is the author of Municipalities in Financial Distress and ESG Critique. She's a contributing editor for Bankruptcy Law Letter. We will be assisted in our webinar by Hunter Drake, a 3L at ASU Law and a senior student fellow with the Center for Law and Global Affairs. For all attendees, please feel free to put any questions that you may have in the chat, and we will save the last 10 to 15 minutes for audience questions. So without any further ado, I will hand it over to Professor Coordes to introduce our esteemed guest, Dr. Neeti Shikha.
Thank you so much, Andrea, and welcome everyone. Thank you very much for joining our webinar today. As you likely know, our conversation today is going to focus on Indian insolvency law. And as you may know, India is looking at some significant changes to its insolvency and bankruptcy code, including some new initiatives to facilitate different forms of financial distress. And so I am so pleased to have Dr. Neeti Shikha, the founding head of the Center for Insolvency and Bankruptcy at the Indian Institute of Corporate Affairs and senior lecturer in law at the University of the West of England, here with us today to talk about some of these changes and to also talk about her own illustrious career. So just to give you a little bit of background before I start our conversation, Dr. Shikha is an international legal scholar specializing in insolvency law, corporate governance, and financial regulation. She holds a PhD from National Law University, Jodhpur, and an LLM from University College London. She's a fellow of the Higher Education Academy in the UK. And before she joined the University of the West of England, Bristol, Dr. Shikha held academic and research positions in India and Singapore, including serving as a visiting fellow at Singapore Management University. As I mentioned, she is also the founding head of the Center for Insolvency and Bankruptcy at the Indian Institute of Corporate Affairs, Ministry of Corporate Affairs, Government of India. In that capacity, she led research on insolvency reform that has informed policy and has been cited by the World Bank. She has also authored and edited several books on corporate governance and insolvency law with leading international academic publishers, and she's published widely in top international journals. So, Dr. Shikha, thank you so much for joining us today.
Thank you, Laura. Thank you for having me.
It is our pleasure. I wanted to just start things off by asking if you could give us, especially for those in the audience that might not be as aware, maybe a brief background on insolvency law and practice in India.
Thank you, Laura. In India, insolvency law is relatively new. The first Insolvency and Bankruptcy Code in India was introduced in 2016 following a Banking Law Reform Committee report. Before that, the insolvency was dealt in a rather unstructured manner. So the companies who wanted to get liquidated went under Companies Act for winding up. Creditors took recourse to securitization laws and debt recovery laws and went to a debt recovery tribunal most often than not. And then for restructuring, there was a board of industrial and financial reconstruction that advised on whether a company could be restructured slash wound up. So insolvency law, which was very fragmented before 2016, got a new sort of consolidated framework under the Insolvency and Bankruptcy Code. Now, 2016 marked a turning point in the history of the country because for the first time, Indian government took a very informed decision about making a major structural changes in the country in the form of not only giving a consolidated code, rather how we look at insolvency as a subject matter. Now, if you look at before 2016, bankruptcy was seen as a bad word, it was associated with a lot of shame. But 2016 government took a lot of efforts to sort of dismiss that kind of perception opinion to say it's okay to fail, companies should have an easy exit, and especially to really to breed the entrepreneurial sort of culture in India, it was important. I'll just take a minute to talk about what was the issues that the law sort of dealt with and how it brought a paradigm shift in insolvency as we dealt. Now, there was a Banking Law Reform Committee report that preceded the IBC code. And in that, it was found out that sometimes the companies would take as long as 10 years to be wound up. Now, by the time a company was decided to be wound up, the final judgment call sort of coming from the courts slash company law board, by the time all the asset value of the company would get eroded. And there was literally nothing for creditors to get to maximize their value. So the idea of IBC was to give a swift, to make a time-bound insolvency for the companies, and companies should decide in case they have to go for in case they go for insolvency proceedings, then it should be time bound. The creditors should have a more say because in our experience from the past regime was that the debtors sort of played folly with the system. They tried to they tried to deal with the assets in a manner that would take away creditors' interest. So there was a paradigm shift in sense of giving the control of the insolvency process in the hands of creditors. And hence, India introduced what's called creditor and control model from the earlier debtor in possession model. And the idea was that creditors in their commercial wisdom should be the drivers of insolvency. So much so, Laura, that in the act and the committee report that preceded, it was clearly enunciated that commercial wisdom of creditors should not be open to challenge by the courts of law. Now, that was like a turning point in India because, I mean, in my lifetime, I've never seen a law that clearly spells out not just what the law is, but also drives the policy, that precedes the law in a very well-spelled legislative framework.
Thank you so much. That is really fascinating. And that's one big difference I know. I mean, just coming from my own background as a US scholar, where we have a very debtor-centric, debtor in possession model, this idea of creditors in control, creditor wisdom really sort of being prevalent, not just in the law, but also in statements from the government. And that's also remarkable, by the way, about the government sort of taking the lead and saying, look, there's nothing to be, or insolvency and bankruptcy, that's not something to be ashamed of. This is something that's like part of the life cycle of a company.
Yeah.
Because I know from as well, not just in the US, but everywhere, there's always fear about stigma and will shame and stigma prevent companies from getting the help that they need to the point where,
Totally.
as you said, all asset value dissipates and there's nothing left for the
Yeah.
creditors because the company's been dragging its feet.
Right. So
Um,
yeah, I mean, I remember there were so many road shows that Indian stakeholders, including the government officers, they went across. They went beyond the boundaries of India. They did road shows in Singapore, in so many other countries, to sort of pushing that kind of the idea that here we have a new framework. There's an easy exit for the companies, and that incensed sort of message, a silent, quiet message to companies that come invest in India. We have a fertile, we have a fertile economy, and we have an easy exit. So, wish in case the companies don't go well, you're not stuck up in this legal system. So, yeah, a lot of effort was done by the government, I would say. And it's interesting to note here, Laura, that single-handedly IBC pushed India's ranking, um, you know, uh, to 61 position in the world's bank's ease of doing business. I think two places where India struggled with the ease of doing business report was one was contract enforcement, which is still an Achilles heel in India, and the other was insolvency framework. And insolvency framework did got a right concern and right address by the government and the policymakers.
that's fascinating to hear. And yes, it's something that I don't know, as a bankruptcy person myself, I always say like you need to have a plan, not just for when things go well, but for when things fail. And so it sounds
Totally.
like that's obviously very, very, very important. So thank you for that. I wanted to just pivot a little bit and see if you could tell us a little bit about your own background, how you became interested in insolvency law, and sort of what led you to where you are today.
Yeah. It's interesting. Given my background, I started my career, by the way, as a banking trainee at banking law training at one of the Magic Circle firms in London. Then I went to do my master's at UCL, and I was fortunate enough to be taught by Anne Fletcher. And learning from right from horse's mouth, you get a different kind of passion and interest in insolvency. And when I was doing my master's at UCL, that was the time where many countries were sort of, you know, uh, designing their insolvency framework, but India still was years behind. I think my initial inspiration did come from Ian Fletcher. Um, Also, I realized that being a corporate governance scholar and a corporate law teacher, insolvency, is something which is inherently, akin into our research interest. Uh, I mean, for me, insolvency is nothing but governance issues in a failing conditions of company. And so when India was designing its law in 2016, I naturally got interested in this area. And I was asked to head the Center for Insolvency and Bankruptcy with the government. It was a government's think tank, Ministry of Corporate Affairs think tank, where I spent good years. And we created the first cadre of insolvency professionals in India. So, just for our listeners and viewers, there were two pathways to become insolvency professionals in India. Uh, and by the way, it was a new profession that IBC gave birth to. Before 2016, there was no insolvency professionals as an entity, as a group of professionals in the country. And the space was dominated by chartered accountants and lawyers. So, with coming of IBC, we got a new profession, and I was spearheading the second pathway to become IP, wherein without any experience, you could become an insolvency professional. The government offered 2 years training, and after 2 years of training, one had to sit for the IP examination, which was conducted by the regulators. And if you'd qualify, you become, insolvency professional. So And that was the time I did most of my policy work, advising on any particular policy that was taking shape behind the curtains, anything that the government was mandating. Interestingly, that was also the COVID time. So if you realize 2016, around end of the year, the law came, and 2019, the countries were struggling with reframing, realigning the insolvency laws to deal with COVID situation. So yeah, it was testing times, and here we are.
Thank you so much. Yes, that must have been, I can't even imagine having a sort of brand new law, training these IPs, insolvency professionals, taking the time to do that, and then COVID hits. So what was that like? How did India sort of, especially, I mean, from an insolvency framework, but how did India think about adapting during COVID, given that it's insolvency and bankruptcy law was only a few years old?
Yeah, that was in fact very was a big testing time for us. But I think as a country and as a center, we were lucky to be benefited by collective experience and knowledge of the scholars across the globe. So I remember we started something called Friday webinar series, where during COVID time we covered around 18 jurisdictions. We got experts from each jurisdiction to tell us how their country were navigating and what kind of reforms they were including in their jurisdiction. Later, the conversation from these webinars got published as a book. And I think that gave a lot of insights into how countries thought about. Now, there were a couple of interesting things that India did. The first thing, of course, was re- uh, just for the viewers. In India, the test for filing for insolvency is default. So earlier, when the code came in to existence, for a default of as low as 1 lakh rupee, which is around £1,000, one could file for insolvency. And so the creditor had a lot of bargaining power to sort of, hold the hands of the debtors, take them to the court and say, you better pay me. And if you don't, I'm going to, start an insolvency proceeding against you. And the data shows that most of the insolvency cases, as high as over 70%, got settled even the formal insolvency proceeding started. So the debtors would settle the cases uh, even before the admission of the application for insolvency. Interestingly, during COVID time, that was raised. The default became up to 1 crore, and we saw. I mean, later one of my research, I saw that there was a incremental drop, a significant drop in the number of cases that got settled. So India navigated through, I would say, learning lessons from the West and across the globe. And we try to redesign our own answers to situations. For example, we increase the threshold thinking it'll give some breathing space to MSMEs so that especially the MSME sectors who are bound to default due to COVID because of the disruption in supply chain would not be, faced with insolvency. So yeah, I mean, I can talk more details about it if you want to know, but I think that was the kind of indigenous answer that we got. Directors' duties, some of them were suspended. Um, so yeah, there was interesting times.
Yeah, that sounds very familiar to my ears, especially, I mean, we paralleled that a bit in the US with our own small businesses, our Small Business
Yeah,
Reorganization Act, and then raising the threshold for small businesses to file under special proceedings. So we had sort of similar, I think,
yeah,
um, reactions to
yeah,
a very unexpected event.
yeah.
So yeah, so I'm curious, I guess, you've talked a bit about how, you became involved with, heading the Center of Insolvency and Bankruptcy. What made you become interested in insolvency reform? Have you become, how have you kind of sort of become involved in insolvency reform in India, not just really at the beginning, but sort of over time?
Yeah. it's very interesting. As an academic, we just can't keep shut, can we? And we have to let the pen do its job. So, because your research is at heart, and especially being from academics, we come from the from the premise of critique. So, my basic premise of any reform that was taking place was that what is the impact of that, and I had spent a good time in policy with policy schools, and and studying policy, how policies are designed. And I knew two thumb rule for policies. One was that you know there has to be evidence to support a policy change, and second was that a policy must address the root cause. I mean, seldom, most often than not, the policy that we changes that we propose, they address the symptoms and not the disease. But if you really want to make a lasting impact, you need to address the disease and not just the symptoms. So, from coming from that kind of school of thoughts, I was fortunate to be sitting at the center, which was think tank of the government. And I was also lucky to have a very good leader who was leading the think tank, Dr. Sharma, who was a mathematician, statistician himself, and he sort of pushed us to do more research, give inputs. And I must admit, Laura, that we gave a lot of, unbiased, objective inputs. Many of them were not, taken into account immediately, because I think governments work in a kind of political economy that is around them, that surrounds them. And in that case, but after moving away from the center, and now that I'm here, I see some changes have taken shape in place. So, just to share a couple of reforms that we proposed, which saw immediate impact and some which did not. So, it's interesting that while IBC was introduced in India in 2016, uh, IBC did not cover financial institutions. And that was because of the design. Because parallelly, the government had introduced a bill for financial institutions called FRDI bill. Now, there was a lot of backlash in India because probably the message in the bill did not go very well in public. And there was a concept of bail-in, bail-in of banks. It did not really sit well with the citizens. And because of public backlash, the government withdrew the bill. Now, when I came to the center and we got a funding from the ministry to do a research where we looked at 36,000 companies' data, and we looked at where are the root problems. And we realized that within the species of financial institutions, different companies behave differently. So it's not and the maximum stress was lying with the medium-sized financial institutions. The big sides were well covered, and so was the smaller sides were also decently cushioned. It was the medium size that was facing major stress. And we also tried to map the FRDI bill against the FSB's key attribute, which is like a harmonized features proposed by the Financial Stability Board for the countries to adopt. And we realized that the bill itself was not wrong. Of course, there were some lacunas. And to cut the long story short, we proposed to the government that this bill must be reintroduced with certain tweaks. For instance, there were some overlaps of power between the regulators, and how do we sort of navigate through that, and how to make it more independent, more, and carefully and clearly designating the powers. And the government did agree to reintroduce the bill, which was like a big, made us all happy because a lot of time and effort was worked on the bill. And just because of public backlash, it was withdrawn, which was not good. So that was one small success that we saw. We also did a research for the regulator, the IBBI. And in our research, we tried to look at the IBBI timelines. So we looked at the complete cycle of the companies that had undergone, insolvency under IBC. And we tried to study the timeline and find out where the delay happened. And just for putting it briefly for our viewers, a couple of findings which was very interesting was we found out that a lot of delay is happening because you know the assets are not finding market, and the insolvency professional had to reissue requests for proposal. And that was because it was incumbent on the IPs to find a buyer for the asset which was to be sold. So one of the proposal was that we must have an e-platform or a common platform for stressed asset. And I'm glad that, we have been able to create one now based on, one of the findings. We also found a very interesting, fact from the case and from the project was, you know, there was no power. I mean, the courts did not agree to appoint, you know, uh, uh, you know, people to. So there was a lot of money laundering happening within the insolvency. And when the creditors went to the court and said you must, appoint specialist people or give some relief uh, based on so that the money is not dissipated abroad, the court did not use its power. And that was not because they didn't have the power in the statute, because the regulation was so widely worded that courts may, and the NCLT did not want to exercise its discretion because probably it was not acting very pragmatic. So we found that there is a provision to give that kind of order, but NCLT needs to show more pragmatism. So, very interesting findings we got from the timeline, and based on which IBBI, the regulator, took further recourse. So, there are more. Um, One example of a policy change that we suggested, which did not see the light of the day, was uh, when government was introducing pre-pack. I and my team suggested to the government that we should not keep it limited to the MSMEs, and it should be extended to other corporates, and especially bigger corporates. And the rationale behind that was that pre-packs needs a very suave, professional, sophisticated minds, and MSMEs may not have that, especially because of want of the resources that they have. But for some reason, it was not introduced, but as see in the latest proposed amendment, we are extending pre-packs to other corporations, which is good news.
Yes. And thank you so much for those examples, because I think they show really clearly how important a role research and academic research can play in terms of actually making sure that the policies that, for example, the laws and policies that the government is proposing are having their intended impact. And even though not everything that you proposed got picked up, it's, I think, very impressive that some things did, and that the government was willing to say, okay, yes, maybe we should rethink this. Thank you, based on the data that you provided and the information that you provided and the informed proposal that you were able to make. That's actually very heartening because sometimes, you wonder, you're putting this research out there, and is it being heard? Is it being responded to? And so it's nice to see that at least some of the time it is. So thinking along those lines, continuing sort of in a forward-looking vein, we talked about at the very beginning of this webinar that India is looking to make some changes with its insolvency laws and frameworks. And so I'm curious as to what you see as maybe some of the challenges, some of the maybe opportunities that India faces as it works to do this, especially maybe in terms of the broader, as you mentioned, sort of the broader political climate. The government's not operating in a vacuum here. These laws aren't being made in a vacuum. So how does India think about these different factors as they work to refine their own insolvency laws and provisions?
Right. I think challenges, Laura, is pretty well known. It's like an open book, all out and open. If I look at the challenge from from the from the institutional perspective, I think there are some structural challenges with the institutions. And I mean, we must remind us all that India, Indian insolvency ecosystem is performing in a very tight environment, in a very strained environment, because, I mean, law is new. We had very limited capacity for the National Company Law Tribunal, with whom the cases rest. They were all understaffed, and very recently we have been able to fill in the vacancies with the judges. So I think the challenges are immense. The road ahead is not easy. Looking at the number of cases that we are coming up, and the judges are being burdened. They we have capacity, but they also needs training. So the commercial wisdom is much talked about for the creditors, but it's I'm not sure how much emphasis are we giving to the commercial wisdom on the judges. And to just share with our viewers that in India, the NCLT members who are like commercial court judges may not necessarily come from commercial practice. They could be a civil law judge who had been appointed in that chair. So I think we need judges training to think like a commercial judge. I think from the structural perspective, I would say another next set of challenge is with the design that we adopt in making policies. I think policies are mostly reactive and not very proactive. And most often than not, then we are doing a very knee jerk reaction to the criticism. And I think that is something I feel the government should be thick skinned and let the law see a few more years, because impact of good law will take some time to show up on the audit books. Now, so for example, there was a lot of brouhaha about the way the COC performs, about the haircut, and a different sort of judgments you would see that sort of tries to disregard. To begin with, voting right was given to operational creditors who are unsecured creditors, which sort of defies the logic of insolvency. Um, and now we have done away with that, but we still need some protection for the home buyers and operational creditors. I mean, home buyer is a class or species that still struggles um, in India. And honestly, we have been able to resolve some cases, but again, as I say, those are the options we adopted not to cure the disease, but the symptom. The disease is that the real estate companies take money from the home buyers, money that comes from the mortgage or the deposit, and they build on a real estate project. Now, in the UK, that's not the case. The real estate investment companies they can take the deposit that stays with the solicitor, but they cannot rely on the home buyers, to build up their real estate projects. So I think that kind of, issues. So I see there's a lot of structural issues. And one way has to be, Laura, that policy has to be more evidence based and more informed. Um, and more mind has to be, spent in it. I mean, look at the cross-border insolvency framework India has adopted. I have been a critique of that. Yes, unilateral model is a good model. I mean, many of my scholar friends, and you would know them, they've argued against the regime. I mean, they say the question of the success of unilateral itself is in question. Even if I agree, I mean, I do agree it offers a very good model, but we have not we have not applied a mind while adopting the way, without reciprocity, we give access to foreign representatives without our representatives having a reciprocal access. I mean, these are the questions that we should really navigate more carefully. And these are real challenges that our professionals would face in resolving an insolvency dispute. And I think somewhere India should not forget that we are one of the largest, growing economy, and we have a bargaining power. So a blanket adoption, transplantation of a model law without, well exploiting the exception that the model law itself has carved for us is not right. And I, very quick signposting. I think we really need to use trust as a currency, Laura. Um, if you talk to people in practice, they will say they don't trust insolvency professionals. They don't trust, the debtors. So there's a lack of trust among the key stakeholders, and I think trust is one of the most important currency in any economy, in any insolvency. Now, IBBI, the regulator, is doing a lot, but if you look at the kind of disciplinary action that's been taken, that is not for the ethical conduct, but that's for the compliances. So if you've not followed a particular procedure, you're being penalized. But I think the regulator has to find a way to establish trust and ethics in the profession. So I think that are the, I mean, I can go on and on with my challenge, but I'm where I maybe sound, I don't want to sound very pessimistic. There are opportunities as well. And I think one of the best opportunities we have is because our law is new, Laura, it's still quite new. Newer realms can be well adopted. Second opportunity for Indian insolvency ecosystem is adoption of technology. India, uh, you know, is technology is cheap, technology is widely available. So I think tech integration into insolvency ecosystem, be it at the level of implementation plans and mapping of that, or be it at the level of creating a market for bidders, there's a huge opportunity.
Thank you so much for highlighting some of those things. I think you were right on with the challenge, like the structural challenges, because as we've talked about, like you can design a great system, but if the underlying structure isn't there, it's just gonna fall apart. And so
Yeah,
thinking about the structure and thinking about sort of proactive design and
yeah.
building that structure
Generate
is so
some.
important. Yes, and so I that really, really resonated with me at the very least, and also, of course, talking about evidence-based policy and making informed policy decisions is so, so
And
crucial.
yeah, and Laura, if I can just also bring attention to one of the another issue that we face is about polyvocality. So you'll see that one bench says something else and the other bench is taking a different stance. So in today's time, an investor cannot preempt what an insolvency outcome would be. Now, even under your Chapter 11, it's not very, I mean, but at least you know what the action of how a particular law would be interpreted by court. Its application may differ, but in, based on the facts. But right now, even the interpretation of law is having different, it is differently interpreted by different benches. And I think legal certainty is at the helm of it. You have to have a certain outcome. To give you one example, there was a case, Bhushan Power, in India, and it was one of these new, uh, early cases where a company went through a very successful restructuring, and it was completely turned around, and it became one of the profit generating entity after restructuring. Now, years after it was successfully restructured under IBC, they were the courts found the allegations of fraud evidentiary, and it sent the company into liquidation after successful restructuring. Now, that sends a very wrong signal to market, which means that, you know, uh, the outcomes are not certain. So I think that legal certainty is very, very crucial for any economy in general. Investors need to know what is the most probable outcome of a legal process in general. So that is another thing that India, and probably this will mature because yours is a very matured insolvency ecosystem. So hopefully we'll follow, a similar way.
Yeah, absolutely. I mean, some of it imagine just takes time, right, to develop
Yeah.
and but absolutely. I mean, it is so crucial and so important to have that legal certainty, and that's something, I think we all want more of. Um, Great. So I'm curious about, sort of the rest of the world looking in as India makes these changes. We talked a bit about sort of cross-border cases in the model law, but I'm curious about sort of, and I know you're based in the UK now, so are there things that the US, the UK, other governments can be thinking about and learning about as as we watch what India is doing in the insolvency space, and then maybe vice versa? Are there things that you think that are going on outside of India that India should really be paying attention to as it works to again change and refine some of its own insolvency laws?
Thanks, Laura. I'm watching India very closely from a very emotional standpoint because I'm an Indian. I grew up in India, spent most of my life in India researching and teaching. And at the same time, the world is watching India because we are the most populated country in the world, which also means we have the highest and richest data in the world, especially given in the very diverse ecosystem that India has. So data are not very, they're not very predictive. They're very diverse, and also because India is gonna be, you know, the third largest economy by 2030, and the world is watching India in short, and especially in the lines that recently India's done a trade deal with the EU, with the UK, which is a very positive news at a macro level. Um, so, couple of spaces I would say to watch is the digital economy. It's amazing how digitalized India is. Like even if you go the remotest of village, people pay in digital form, and mobile data is cheap, which means that you can use their mobile to do multiple transactions. I think there are certain financial sectors which has been very less exploited in India. Um, I mean, debt is a there could be there's an opportunity for huge debt market in India, especially because given the level of NPAs that we had, and which may be in the future, there's a huge debt market, which is also an opportunity in hand because then it means you can have a newer debt products, and can really well exploit that financial sector. So I think that area is here to grow. Also, if you see, there's a very high domestic capital in India, um, which means that if government has to ease the licensing for opening banks and allows corporates and ease corporates from opening banks, maybe allowing the conglomerate, you would see a lot of indigenous stories of Morgan Stanley or the like, because there is capital in the country, but the regulations have not allowed corporates to sort of open these financial institutions and become bigger. One thing I think world could sort of learn from India, especially in the banking sector, I would be the way India has navigated through, preempted and navigated through banking failures. I always joke with my students and say about it's not just arranged marriages in person, but it's also a forced marriage in banks that has happened in India, which has saved banks from failing. For instance, there's a forced merger. I mean, it's literally a forced merger where, if a bank is not doing well, a public sector bank will take over the weak bank and absorb the losses. And it has really sort of contained the kind of a contagion that may have spread in the financial market. So yeah, I mean, there's a lot of scope of exploiting these sort of opportunities that the country has, and also sort of a friendly suggestion to my own country that because world is watching, we need to really remove the Achilles heel, which is the execution. I think the two major problem has been one of the structural and the other is execution. Structural is still easier to deal with, but the problem is mostly with the execution, how you execute the laws, and especially in a revolving ecosystem where one man designs the framework, moves on, and the second man takes it. So the procedures have to be very well placed, structured, documented, so that They remain in institutional memory. So yeah.
Thank you so much for highlighting some of those challenges and opportunities. And I know it's an exciting space. There's a lot of change going on, a lot of growth, so much growth in India. And so I think we're all watching India, even those of us that don't have such a strong connection to it as you do. But there's so much to watch in this space. And so I appreciate
Yeah,
you.
even right now, Laura, the growth rate is 6 to 7%, which is sort of
Yeah.
unprecedented for any economy, especially by the dint of size. And yeah, so
Yeah, it's really incredible. It really is a much must watch space. So I think regardless of where you are, and especially of course in the financial sector as well. So I do want to make sure we have time for Q&A, but I did want to just ask, is there anything that I haven't asked you that we haven't talked about that you think is important to share that you'd like to highlight before we sort of open it up to the audience?
um, I mean, my three sort of you know yarns or takeaway for the audience would be, I mean, if you're a student, you're in a really right time because, I mean, you would know, Lauren, I would remember that when we were students, Hunter, you may not agree that we grew up with a very indigenous, localized view, and then we evolved to have a world view. In today's time, students are growing with a global view, which is amazing. You know, you can be in your seat at university in America or anywhere in the world, and you can still know about what's happening in the other country in real time. I think that also this generation has a very huge risk appetite, which is amazing for financial market. And I think the solutions that we highlighted in our conversation, some of those answers could come from the next gen researchers and students, integration of technology, so to say. Um, if we are policymakers, my key suggestion would be we need to keep coming back to the book of learning and drive only for evidence based policy making. Policy making is not emotion, it's about evidences, it's evidentiary. And also, when we design policy, I mean, US is very mature in that respect, but India has something to learn from there. You know, how to bring in behavioral insights from economics in designing the policy, um, and especially in insolvency ecosystem and in personal insolvency space. You know, we talk about doing away with shame. So, what other behavioral tools that government or policymakers could adopt? So, if your policymakers, you know, go on the evidence and look at the disease and not the symptoms. And if we are researchers, I think there are newer challenges we researchers are sort of facing. For example, you know, there was, I mean, the whole concept of waterfall, for instance, it was so, you know, it was biblical literally, and we have to sort of follow that. But with new stakeholders' voice being taken in account, we all as a countries are revisiting a waterfall mechanism, waterfall. We're also revisiting how we look at the climate, you know, insolvency and environmental liabilities, and these are the issues which are not yet certain, so which are evolving in nature. So I think we as a researcher have a lot to contribute to in the future. So yeah, I mean, we have to keep working and taking the right path, and there's always light in the end of the tunnel. So things might look gloomy right now, be it economy wise or whichever way, but keep reminding yourself, you know, there's always the next dawn.
I think that is so great. And I think that's especially inspiring for the students that have the capacity who right now are students, but they are future policymakers and they're future researchers. So it's really great advice for everyone, for those who are policymakers and researchers now, but also are future policymakers and researchers. Like you have such an advantage, I think, growing up, so to speak, in this system where you can experience the world basically in real time. And that's something that I didn't have when I was going to school. So I think, that also gives me a lot of hope that,
Yeah,
we will be like this next generation will be thinking about these issues
yeah, yeah,
differently and maybe more thoughtfully than
totally,
maybe some of us did.
totally.
So I want to open it up to Q&A if we have questions from the audience. Otherwise, I'm happy to ask more questions, but okay. Um, so Neeti, I wanted to come back to something you said a couple of minutes ago. And again, if you have questions, I think audience members can feel free to drop them in the chat, and then Hunter will make sure we get them. But while we're waiting, I wanted to come back to this idea about the importance of trust as a currency and finding ways to establish trust, especially again, with India particularly, their insolvency system is relatively young. But do you have thoughts on how we can get that culture of trust among practitioners, for example, and IPs or practitioners and debtors? We think about this a lot, I think, in the US in terms of like the regulation of the legal profession and ethical codes and all of that. But I'm curious as to if you have thoughts about how to develop trust, especially when it is sometimes a new system and people are still finding their footing.
No, Laura, because that's something which a question that keeps grappling me. Because I would share that India as a society, and we all are, products of our own society, we lack trust immensely. I mean, I mean, there is a lack of trust not just on professionals, on any profession, and that probably is because the institutional accountability over the past so many years has not been there. Unlike, and sometimes governments have to sort of, take a step and send a strong message to retain that trust in the system. When the Insolvency and Bankruptcy Code came in, there was a list of dirty dozen, list of companies, banks. Um, um, they were basically individual slash companies that was seen to have played a major role in the increased NPA, individuals who literally took money from the banks and ran away, and they have not come back to the country to serve their, to even subject themselves to the legal, trial. Now, I heard a news the other day from India that one of the banks, people had put them, gold in the locker, and the gold has been stolen from the banks. So I feel that when you talk about insolvency ecosystem or any economic law for that matter, market economy works on trust, and so I don't have an answer how we establish it, but I think few ways which I see, especially in the UK, I think is a very evidential here that people work on trust. And on a separate note, I was telling somebody that every British people thinks that UK is here to doom because of the economy. And I say, you will not, because your institutions are very, very strong. And in any country, when the institutions are strong, then the country will survive all these, um, cyclical, downturns. So I think the trust is something that has to be instilled from very young business. So when you don't glorify success and you celebrate failure, that is one way to establish trust. uh, Many of these businessmen have run away because they knew that the law, once the law has them, will not let them go. They can never have a second start or a fresh start in the economy. So I think the basic premise is that not to glorify success, and not to stigmatize failure from the institution level, having more accountability of the institution. Then everybody's energy will be spent in what they're supposed to do. For example, currently the Insolvency and Bankruptcy Board in India, most of their energy is looking at whether they've done the compliance or not. And if they're not complied, they're not filled a particular form, then you penalize them. Now, later technology can take care of all this, And what they should then be spending their time and energy is about making good policies, building the trust in the economy, and so on and so forth.
Thank you. That's a great answer to a really tricky question that I posed about trust and something that I just, wonder
I
myself.
mean, what do you think about American society? How do you think trust has been established for so?
It's such a good question. And I was trying to reflect on that a little bit as I was talking to you. I mean, I think some of it is just we have like this long history that's been built up over time. In the bankruptcy specific sector, I think one thing that's been particularly helpful is that our bankruptcy judges do tend to come from practice and come from like a commercial law background. So there's this inherent idea that, oh, these are specialist courts and they know what they're doing. We may not trust the upper levels of courts that are reviewing our bankruptcy judges' decisions, but we trust our bankruptcy judges. But I also think it's something that's really grown up over time because we've had to sort of we've had some trial and error. We've had some issues where there have been serious breaches of trust. And so, I think in some ways we're still learning the answer to that question, at least, from my perspective in the bankruptcy space. Do I have time for another question?
You do, and I have one too.
Oh, okay. So I'm gonna, yeah, I'll turn it over to you, Andrea, for a question
No,
because I've been
very,
hogging the floor.
no, very quickly, Neeti. I was just wondering, as you mentioned, there's going to be this shift, especially now with these 15% tariffs, as India shifts away from the US towards the EU, which is a much more regulated, much more legislated market. Do you see any potential impacts on that exposure, immersion of the Indian commercial of commerce into that system, having been in a much more freer, open market as more similar to India as they shift towards the European Union?
So, very interesting, Andrea, and not that it's my area of expertise, but just to share a couple of things that, EU was a very strong partner, especially in agricultural food, but, there was a lack of capacity building for the farmers. And because of which there were certain concerns EU market had with Indian mangoes, Indian shrimps, and these trade stopped in it, uh, I feel that with the trade with the UK and EU, it will raise the Indian standards, which means that now if the farmers are better informed, there'll be more capacity building, and you will see a finer product. I mean, labor still remains cheaper in India. Tech is cheap in India. So you will see that if the standards raise, they could be a good partner. My concern is different. I feel that most of these partners see India as a market and not as a partner. So, I mean, if you're seeing India as a market, of course, there's a big market, but that market government is trying to protect for its domestic producers. One of the reasons why we survived COVID and we still have the growth number because we have a huge domestic consumption and we are not relying so much on the external supply chain. Having said that, US is a strong partner. The prices in India will go up in case the tariffs don't come down, and that will not be very good for any of the trade partners for India, even for EU for that matter, because EU could have benefited from India buying cheaper oil from some other source than from Venezuela, which may be expensive. So within the supply chain and distribution, everybody could have sort of benefited if India does it right. I mean, right in sense, not morally right, but right in sense that economically right. So I don't know, but I think we are just waiting for happier days and wiser days ahead. Um, uh, I mean, we are in the Orwellian era, right? And we're just waiting for the clock to strike right, and we'll see. But yeah. Now, having said that, Andrea, I'm not sure if you know, a lot of many universities have opened up their market in India. So many UK universities have come up, opened up its campus. And recently at the AI Summit, we had a situation where there was sort of plagiarism of technology. There was a Chinese bot shown as their own by an Indian university. And there was lack of verification by the government officials who sort of retweeted saying it's an Indian bot, whereas it was later claimed to be a Chinese bot. I mean, in the whole fiasco, which I recently wrote for a newspaper, is also that, and there again, the emphasis on trust, that because see, thus these incidents will send their ripples, and the partners will be very concerned that one of the concerns with partnering with China for retail is that, oh, does it have health hazard? Does it have, child labor products? I mean, is it a fair trade and the likes? So I hope that in Indian context, is it of a good standard? Is it safe for usage? So that is something that will concern us. My scholar friends argue that it will raise the Indian standard. We'll have to wait and watch. Just to signpost on something very interesting, trust has not been a currency which never existed under Indian culture. Interestingly, in India, as if you go to the old ancient insolvency laws, if a father could not pay the debt, the son would pay it back for the father because it was seen as a debt from, pitri rin, I mean, which translates is debt of father, literally. And they would do it. Otherwise, it was linked to us attaining, moksha, I mean, which means we'll always be indebted in our next life. It don't pay up the debt in this life. I think it was also some of the impact of the British colonial system, the lack of trust within the public, and which only grew with time. And with the resources being limited, it only amplified within the citizens. But if we go back to our own cultural roots, trust was a very strong currency. People gave their words, they will really honor those words under, under Hindu law or any law for that matter in India. So, yeah.
Thank you so much. Do we have any questions that have come in from the audience? I just want to check. Oh, okay. Yes, I see there's a question in the chat. So the question is, when we talk about the shift in the culture of trust in India, how do we achieve it? How does that cultural shift occur? India still hasn't enabled its personal insolvency regime. When do you think that's possible?
I don't have answer for the first, Laura, because I really don't know. I mean, I strongly believe ethics, culture, trust. This is something which is infused from a very young age. So to my 9-year-old, I tell her, you got to do the right thing even when nobody's watching. And that's how I try to train my young daughter. Coming to personal insolvency, I think it will be implemented soon. My worry is not about when it's implemented. My worry would be how it's implemented. To just give a context for the UK, US listeners, now in India, student debt is not a big issue, but credit card and household debt is a big issue. So now the new insolvency framework that we're trying to introduce would say fresh start under certain, up till certain threshold it'll be written off and person could have a fresh start. Now the threshold is so low that it means you're only serving to the poorest of the poor. I'm not even sure that poorest of poor in the economic chain does he even take a credit card debt or a household debt? Because that population, to my understanding, would be relying on free meal from the government, free housing support from the government. I think we need a system that promotes entrepreneurship, at the same time does not become a burden on the financial institutions. Now, for that, I think the newer products, newer loan products, newer market, uh, you know, those things have to really be reinvented in the country. So, and then insolvency ecosystem for personal insolvency should focus on the debt advice and not just about diminishing the liability post insolvency, rather advising a person to act with more financial wisdom. So I think my concern is not about when, it's about how, Shiv, how we implement that, personal insolvency framework.
Yeah, that's such a great point too about thinking about the how you educate consumers and as to how to manage their money and not fall into insolvency in the first place, and that being, somewhat of a separate issue from how you get them out of the mess that they may find themselves in. That's a balance that I know we're still very much struggling with in the United States and trying to figure out like how much attention do you pay to this, and how do you sort of make sure that people don't make
Yeah.
those mistakes in the first place?
Yeah.
Well, I am cognizant of the time. I don't want to hold you any longer than you've already been so very generous with us, and we have covered so much. So really, I just want to thank you very much for this conversation and for joining us today. I think we've talked about a lot. I've learned a lot. So really, thank you so much for your time. I do want to make sure I turn things back over to Andrea, who will offer some closing remarks.
Yeah, thank you so much. Also, Professor Coordes and Dr. Shikha, for this discussion. We are going to be posting it, so hopefully we're going to get more people involved, and hopefully it's just the first of Professor Coordes's webinars. I'd love to have one on EU comparative insolvency law and just hear what possible impacts they're going to have once India enters that market more strongly. So I just want to let everybody know that the week of March 3rd, we are going to have a webinar on the peace agreements between Kosovo and Serbia. We are having the former UN head in Serbia and US representative in Kosovo speaking on that, and two civil society members from Kosovo and Serbia. So keep looking in your mailboxes waiting for your invites. But thank you all, Dr. Shikha, Professor Coordes, Hunter, and Julia. Thank you both so much for organizing this.
Yeah, thank you. Thank you, Professor Andrea and Professor Cordes. It was really a pleasure talking to you. And Hunter, thank you for all your patient hearing, and Julia for setting this up. It was truly a pleasure. And I'm really proud to see how your university has created this kind of platform where we could learn from each other's jurisdictional experiences. So thank you so much for inviting me to this platform. Thank you.
Thank you.
Thank you.
Okay.